Was it exciting? Did you have to make some calls?
There were a lot of calls made for a lot of songs in this movie. Honestly, like this movie, I think that like when you see it, it feels like a big, beautiful summer movie, but like we didn't have any budget. So there were a lot of favors and a lot of begging and
Your niece for Taylor?
I mean, honestly, she was with me on this experience the whole time, all throughout it. So like she really lived this with me. Yeah, she was, she's a person who shows up for you, and I'm so grateful to have that love and that support. But yeah, there were other people too that I had to call and beg, and people that said no. But I don't know what that means. So if somebody has a dictionary, I would love to find the definition of that. It's so confusing to me. No, we just begged to get a lot of the songs in the movie, songs that we couldn't afford, but people.
Hi besties, it's Katie from Without a Crystal Ball. Welcome back to my channel. What if I told you that back in December, Blake sent out a press pack to different media outlets and provided them an attachment of screenshots that were never actually submitted to the CRD? What if I told you that in December, the LA Times published with an attachment an exhibit that included pages of text messages that are not a part of her complaint today, Blake's complaint, and also go as far back as May of 2024? And what if I told you that none of those text messages were actually in the CRD complaint, nor were they filed with the CRD? And yet some of these text messages also refute many of her claims about a smear campaign. The reason why Justin Baldoni and Wayfair are so confident in their case is because they know that no smear campaign happened. Why? Well, I told you that I spoke to an insider, and I've also talked to people that know Justin, and I've spoken to people connected to the film, and it's a factual reality that there was no smear campaign because there was only a very short time and window that the smear campaign could have ever even taken place because Blake decided it was a smear campaign from day one. She was already gunning for that narrative of it being retaliation on day one. Any negative feedback she got, she was going to blame a smear campaign. That was the motive because of the retaliation clause that she put in her 17-point agreement, which meant that she would be able to sue Justin Baldoni. Within these exhibits that she provided, which do not qualify for privilege because they're not attached to any document and they were not filed at all with the Department of Civil Rights in the state of California. I have a full FOIA request, which gave me every single document from the CRD. And I can tell you for a fact that these exhibits were never filed with the CRD. These were published by the LA Times, and they were also attached in the New York Times. And on the very first page of this, a text message that she literally is ignoring and proves Ryan Reynolds' involvement. And it also proves why Mr. Baldoni, Justin, began documenting everything that was happening. I mean, they had been before, but they got even more into documentation of all communications because of what was happening and the threats that they were receiving. When they were fighting over the cut of the film, and Blake was fighting about editing, and they were doing these screenings to see whose cut would be won, and like what audience liked better. Was it going to be Justin's cut or Blake's cut? And when she was making all of these threats about not putting Taylor Swift's song in the trailer, withholding signing her contract, arguing about, getting more time with an editor, they were trying to get more and more control over the film. And on May 17th, the very first text message of her exhibits, Jen Abel sends a text message to Justin Baldoni. and it says, he blocked you? Is he a 12-year-old girl? Ugh, this kind of behavior is ridiculous and part of the whole plan to keep chipping away at you because they know you will notice this kind of stuff and then likely acquiesce more to her demands. We can put the plan down on paper and work with Jamie and Ashmi to make sure we have all the documentation needed of what happened on set, who witnessed what, and who would be allies to go on background if needed to shut down her claims. And then a timeline of everything Wayfair did to ensure it was a safe set. We will go through this together. May 17th, Ryan Reynolds blocked Justin Baldoni. Ryan blocked him. And it was because he was refusing to acquiesce to their demands. And those were threats coming up about what? We're going to go to who? The New York Times, and we're going to sue you for what? Sexual harassment? We're going to tell them what you did on the set? She included that text. And I remember when I saw this before she started publishing all these motions and I got distracted by all of the filings that are mostly irrelevant. I thought, that's so weird. Why is Ryan so deeply entrenched in something that literally has nothing to do with him, right? And Ryan keeps saying in his court filings he wasn't involved, he was just a husband, blah, blah, blah. Why would he block him on May 17th? What was happening on May 17th? Because I don't know that fans noticed the unfollowing or block until August. And perhaps people weren't even really paying attention because, I don't know, they just weren't paying attention. Why would he have blocked him? Well, because on May 13th, Sony and Wayfair, they did an official audience test score of his cut. He scored 94% with females under 35. 74% of the people that saw the film would recommend it. 94%. May 16th, they released the trailer to the world. May 18th, Lively hosts a friends and family screening of her cut in New York. She does not share any audience feedback with Baldoni or the studios. Ryan blocked him when they were fighting over who was going to get the cut of the film, which has nothing to do with sexual harassment. Nothing. They were fighting about Blake getting the cut of this film at that point in time. May 18th, they even have it on the calendar, friends and family in New York. By May 20th, Lively threats to withhold promotion of the film, as well as her barely veiled threat to end Baldoni's career with a slew of false accusations. The studio reluctantly agreed to do an official audience test of both versions. The decision was made on the understanding that Lively had agreed with Sony that if his cut tested higher, she would drop the matter and fully cooperate. Test scores come back. She scores 82. He still scores 94. Only 59% will recommend her version. Ryan didn't block Justin because he was a sexual predator. No. Blake and Ryan wanted Blake's cut to be the film because Blake wanted to make her actorial debut. And when she couldn't get that, then she took over producer. But they also wanted the marketing. They wanted the marketing of the film. And who was going to get paid for that? Ryan. So why would she put out these text messages that show that it was Ryan blocking them in May that got him to realize that they needed to start documenting everything? Because Justin responded and said, I need to hire a person to help me document everything. I can't live in fear, not willing to, but I need you guys very much to have a real plan so I can feel at ease. Terrified of what they were going to do to him. Terrified of what they were going to do to him, not him retaliating against her. I also noticed within her CRD complaint and her amended complaint and her third complaint, I don't know, she's had a million complaints. She has evidence that is extracted from Cellbrite, which is a forensic tool. And then she also has actual screenshots, which would have been taken off the phone, suggesting that there were two separate formats used to extract data from that phone, suggesting that she had two separate methods that provided her information, meaning before it was ever forensically extracted, she was given screenshots. She has a screenshot in there, the exhibits, where I don't even know, it doesn't have a date. It's got to be maybe in August, and it's between Justin and Jen. The photo is a screenshot because it was obviously taken on the phone because it says today at 6:15 a.m. And there's no way that Blake had access to this phone on August 2nd, which is the date that Justin's messages, which are shared in the timeline of relevant events, indicate this was sent. So this was extracted from Jen Abel's iCloud, where her photos were stored as a screenshot, not from the data, as Stephanie Jones would like everyone to believe in what her lawyers have falsely argued in court and lied to the judge about. And here's what the text message is about. The documents that were sent by Melissa Nathan to go over their strategy for how to manage the PR and the crisis that was coming their way with the release of the film. And it's just odd because the 99.9% of these documents and these text messages are in this data form that are extracted from Cellbrite, which is a data extractor forensic tool. Because she has one text message where it's like, I'm not in love with the document they said. I'm not sure that I feel the protection I felt on the call. And then all of the subsequent conversations are apparently Cellbrite. That's weird. Did Stephanie just give her this one screenshot to make it look like it was a smear campaign? That's what Justin is saying in his motion to dismiss the response when it comes to Stephanie Jones. It's also what Jen Abel is saying in her motion, her response to the motion to dismiss is that they had provided text messages to Lively and they know this to be a fact. And then they needed a cover for why it was legitimate. Because had she disclosed those in August, Stephanie would be violating her confidentiality agreement with her and Wayfair, who was her client at the time. And also, the narrative that this smear campaign was happening was fostered by Stephanie. Stephanie is the one that told Blake it's a smear campaign. Blake already believed it was, but Stephanie was like, yeah, you're right. It's a smear campaign. I noticed this earlier this week. And as I was looking through the documents, and I was like, this is so weird. Why would she include all of these exhibits? And then why would only like one or two of the screenshots be an actual screenshot from the phone? The rest look like they're extracted from data. But she's got a couple screenshots in here, okay? I made the decision to review the screenshots of what was taken from Jen's phone, and I wanted to take a look at the validity of these claims. Was Jen Abel's phone being tracked? Was she literally intercepting things in real time? Was she truly just taking information that was data that was stored on the phone? Or was she taking information that was online? So there's a difference of going into a phone forensically and getting the data that is stored on the phone, meaning a copy of the text message that's stored on the phone itself, not on the internet. It's stored in a file, and they have all these different files that they can search where a copy of your messages, your emails, all get stored onto the phone away from like your inbox. And you don't need to be online in order to get that data because it's actually stored on the phone. But Blake and Stephanie actually screwed up because Wayfair in their timeline of relevant events actually shows the text message screenshot that Blake put in those exhibits, which is the good morning, I'm not feeling that protected. And it's clear that Jen Abel took a screenshot of that and then sent it to Melissa Nathan that same day. And so she sent a screenshot of what Justin told her, and then they have it in their timeline of relevant events, which shows the full context of Jen sending this text to Melissa to show her what Justin is saying. But because they didn't have that string of text messages for whatever reason, and that text wasn't extracted from the phone, they had to get it from the photos. They were able to get pieces of the texts, but they couldn't get screenshots that were shared via text because those were in the iCloud. And so Blake and Stephanie accessed that iCloud to get the screenshots that Jen sent to people. So they are confidently saying something in this motion to dismiss, and they are not saying it under information or belief. They are saying this as a fact. They have evidence to stand behind this. And it says, Jonesworks argues that data stored on personal devices such as Abel's iPhone does not satisfy the requirements for an SCA violation. However, Abel alleges that Jonesworks accessed her communication stored on cloud-based servers owned by Apple and Google. AM Counterclaim 64. Courts have consistently held that such cloud-based systems are the types of facilities that the SCA generally protects. So her allegation is that JonesWorks accessed her cloud-based accounts without authorization that was sufficient at all. Like she didn't have the rights to do this, and she makes clear in her response to the motion to dismiss that Stephanie never had any sort of policy for the phone as far as like personal use versus work use, and absent that policy, which a employee can consent to or not consent to. So if an employee knows that if they put their cloud on your company phone that you might access it someday, that employee can then opt to maybe get their own phone. But if you don't have a policy, they can't opt in or opt out. So Stephanie needed to have a policy and she didn't have one. And that's a huge part about invasion of privacy when it comes to employees. And simply owning a phone doesn't mean that an employer has a right to search it, because that data still belongs to the employee. Something I noticed also is they wrote, Abel asserts statutory claims arising from her unauthorized access, copying, and dissemination of her private communications and data purloined from her confiscated cell phone. Federal and state law prohibits the unauthorized accessing, copying, and disseminating an individual's private text messages and emails without consent. The fact that JonesWorks owned the iPhone did not vest JonesWorks with right to extract her personal data from a non-JonesWorks cloud account without consent, which Abel never gave. Abel's claims are well supported in facts and law. How do they know for fact that she was on the cloud? How do they know? I can tell you why. This is how they know. In one of the screenshots that Blake Lively provided in the CRD complaint, that she also provided in her amended complaint, proves that Stephanie Jones was accessing the phone's cloud and data, not the stored information, but the data from the iMessages and the data from her phone, because there's a screenshot included in her complaint, in her exhibits. It's from Jen Abel to Justin, and it says, this is what we would need. And at the top of it, you see it says today at 12:06 p.m. Well, that's weird. Why would she know something that happened today? How did a screenshot happen today? According to Justin's timeline of relevant events, the text message where he sent the Hailey Bieber article that I just showed you was sent on August 5th. How does Blake Lively have a screenshot of a text message that says today on it? How does she have a screenshot that says today on it of August 5th when Jen still had that phone? Jen still had her phone on August 5th. Jen Abel's attorneys through Wayfair have made clear that it wasn't just that Stephanie Jones accessed her phone data, but she accessed her photos, which were saved in the iCloud. They screwed up because the screenshot that was shared in Blake's CRD exhibits is likely a screenshot that was taken by Jen Abel on August 5th and extracted from Jen Abel's photos, her photos in her iCloud. Over and over and over, Stephanie Jones has lied and said that she didn't access the photos. She didn't access the iCloud. She didn't access X, Y, and Z. How does she have a screenshot then of a photo of a text message sent on August 5th when Jen Abel still had her phone? Stephanie said she didn't monitor the phone before August 5th. So we have to assume that this was a screenshot that Jen took and perhaps sent it to maybe Melissa Nathan to show Melissa. Like she passed it on, like, this is what we need to send. Because Blake Lively's amended complaint doesn't include a Cellbrite extraction of the text message photo that she shared in that exhibit list. Her amended complaint doesn't have the forensic extraction of the Hailey Bieber text. It's more than likely that that text message was deleted off of Jen's phone because it's not in the forensic data, but a copy of it existed as a screenshot in her photos, meaning This is why they can confidently say that Jen's iCloud was accessed by Stephanie Jones. In her motion to dismiss response, they say that Abel asserts statutory claims arising from Jonesworth's unauthorized access, copying, and dissemination of Abel's private communications and data purloined from Abel's confiscated cell phone. Federal and state law prohibits the unauthorized access, copying, and disseminating of an individual's private text messages and emails without consent. The fact that JonesWorks owned the iPhone did not vest JonesWorks with right to extract Jen's personal data from her non-JonesWorks cloud accounts without consent, which Abel never gave. Abel claims are well supported by fact and law and are from more than sufficient to survive dismissal. In the middle of litigation, Jen Abel realized that her iCloud was still connected to the phone that Stephanie Jones owned. How would she know that another device is connected to her iCloud? It's easy. On your current iCloud, you can go into the settings on your phone or any device connected to it and see what devices are still connected to your iPhone. If you change the password of the iCloud, any other account that's connected to it automatically gets booted off your iCloud. Okay. So in my house, on my iCloud, I have my account, my husband's account, and my son's iPad. And anytime I change my Apple ID, everyone else gets kicked off the iCloud. Or I change every time I change my password, someone gets kicked off the network. But you can see who's on your network in your settings. So this means that while in the middle of litigation, obviously maybe working with an attorney, they could see that Stephanie was still connected to the iCloud. And they are saying that they know that she was still connected to the iCloud, meaning that her text messages were automatically going to Stephanie the same time they were going to Jen. Like my son's iPad is connected to my phone, so he gets a copy of all of my text messages on his iPad. I know it's weird, right? You can disable that part of it, but two devices can get the same text messages. And so what they're saying is that the amended counterclaim explicitly states that after Abel left JonesWorks and after JonesWorks seized her phone, JonesWorks accessed her iCloud account and used it to monitor her text messages in real time and contemporaneously with their transmission. Where multiple devices are logged into the same iCloud account, both receive messages in real time. This is precisely the type of interception FWA prohibits. Simultaneous receipt of emails is interception under the federal wiretap law. So, under the law, Stephanie Jones, when she took that phone, should have disconnected it immediately from the iCloud. Immediately. But she didn't. It remained connected to the iCloud until January when she changed her password, and then Jen could see that no one else was connected to her phone. Stephanie can lie all day long and say that she wasn't accessing the cloud, but she gave screenshots to Blake from the cloud that were stored in the photos. Blake screwed up by sharing these screenshots. Blake doesn't have a copy of the actual text because the text wasn't stored on the phone. It was stored in a picture in the cloud. And Stephanie and Blake are so arrogant that they somehow believe that these people cannot put together these dots because Jen can seemingly go into her photos and see, did I take a screenshot? And if it's as a screenshot in her iCloud, she would know that they took this photo from her iCloud. It's not rocket science. So Stephanie and Blake can pound their hands on the table all day long and say nothing illegal happened here, but it did. Blake had no right to have a photo screenshot from somebody else's iCloud and iPhotos. Stephanie Jones had no right to access a personal iPhone and iCloud because it doesn't belong to JonesWorks. Screenshots and photos are stored in iCloud if you have your phone set up to iPhotos, which is what Jen says her phone was set up to. She states that her photos were in the cloud. So those photos are not on the phone. Anytime she went and looked at photos, she was going into Jen's cloud. Anytime she turned that phone on, it was getting text messages and emails that were already set up on that phone, which she clearly did not disconnect from the cloud. Brian Friedman and Mitchell Schuster are not going to bring these kinds of claims if they didn't have proof. And her attorneys, Stephanie's attorneys, trying to act like these are fantastical stories. It's just deflection to try to explain away what they've done. And they'll say, well, they dismissed these other claims. They dismissed the invasion of privacy and the data stuff from the state of California and placed them in federal claims, Stephanie, so that you can't fight with them over jurisdiction. And if you put a federal lawsuit in a federal court and you add federal claims, no one's fighting over if it's New York law or California law. It's all under federal law. And federal law has clear laws on data protection and employers not being allowed to access private and personal accounts, even on an employer phone, without consent. I believe that their motion to dismiss is so well put together, and I think it's summed up best with this paragraph. Jennifer Abel's amended complaints arise from the theft of her private data by her former employer, Jones Works, and its principal, Stephanie Jones. Having pillaged Abel's personal iCloud and email accounts, Jones Works has undertaken a malicious campaign to villainize and humiliate her and destroy her professional reputation. Mission accomplished. Abel now asserts claims for violations of multiple data privacy statutes, as well as common law claims for invasion of privacy, infliction of emotional distress, and fraud. It's feigned outrage notwithstanding. Jones Works' arguments for dismissal are weak and convoluted. They have been yelling and screaming that everything Wayfair does is feigned outrage, but the truth is they're the ones feigning outrage because they know they did this. There is no way that Blake would have a screenshot from the iPhone without accessing the cloud, which is a protected computer. They're not going to put these claims in there if they can't prove it. As set forth, Abel amply satisfies her pleading burden. As for her data privacy claims, Jones Works violated Stored Communications Act by accessing Abel's text messages and emails from cloud-based servers owned by Apple and Google without authorization. She intercepted her messages in real time through iCloud after Abel's termination and the seizure of her phone. Under the law, it is illegal for an employer to look at any messages after the date of termination, which means the day that she was terminated, Stephanie, under the law, needed to disconnect that phone from the cloud, period. She has no way to justify that at all. There's no justification for her not disconnecting it from the cloud. None. She has no legal right to anything that's on that cloud after the August 21st. And yet she stayed connected to the phone. And she sent screenshots from the phone to Blake. And then she told Blake falsely that it was a smear campaign when she knew full well it wasn't. But the second most abysmal mistake that Blake made was that in the screenshots that she provided in that exhibits to the New York Times and to LA Times, which was never filed with the CRD, and she has not provided any of these screenshots to the court, there's actually a text message of Justin talking about a story that Ryan planted with the Daily Mail about the script being a failure. And they're not talking about a smear campaign. They're talking about flipping the narrative because Ryan literally put out a story that he had to come in to save the script because the script was a disaster. Okay. And on August 15th, there's a text message that she included in her exhibits from Justin to Melissa and Jen that says, quickly, my partner Steve asked about flipping the narrative from this leak this AM about Ryan saying the script was a disaster and he saved the movie. About Ryan claiming the female hired was feminist writer, didn't know how to tackle a female film, using their own words against them. Jen, this went so well, I am fucking dying later that same day. So Ryan leaked a story in the morning of the 15th to the Daily Mail that he needed to save the film. And Justin's response was, can we get our side out so the narrative is not that he came in and fixed the script, but that he actually believed he knew better than the woman that wrote the script, who's a feminist. And his own words, that the writer who was a woman didn't know how to write a script, which is actually the anti-feminist that they've been talking about. Like, how does Ryan think that he's a better writer of a woman's story than a woman? Ryan's the one, or Leslie is the one that put that story out with the Daily Mail on the 15th. They're flipping the narrative because Ryan's team is saying Ryan had to come in and write the rooftop scene because that script was a disaster and the book and the film was going to fail. And if he hadn't have done it, it would have been terrible. Why wouldn't she include that? Oh, you mean Ryan leaked a letter, leaked something to the Daily Mail, and half of what they were doing was defending themselves of the smear campaign that Blake and Ryan were launching against them? When you start looking through these exhibits, you notice that it's all defense. All they're doing is trying to bang out and get ahead of all of these leaks that Leslie's doing to the press. Ryan needs to save the script. Ryan had to write the scene. He's going to help Blake. Everything's going to be great. The very first article that came out about this feud was not leaked by Mr. Baldoni. It was Blake's team accusing him on the 9th of being chauvinistic and abusive on the set. She's the one that made the first jump. She's the one that started the smear campaign, and all they were doing the whole time was defending themselves. And so Blake's exhibits, actually, that she didn't share with the court because these would prove her theory wrong, she put these out in December before anyone had time to see what Justin had, right? And once she saw what Justin had, all these other text messages suddenly disappear and now they're no longer part of her narrative. Why doesn't she admit that her husband planted a story that he needed to save the script and Justin had to respond to it because it's his film? It was never a smear campaign, just like Stephanie Jones absolutely accessed the cloud. They are so arrogant that this is why no one can believe they're taking this to trial. They really screwed up with this. And the motion to dismiss response today really made me do a little bit more digging to verify, how do they know that the cloud was accessed? And that's how they know, because Blake has photograph screenshots that were not extracted from the phone data, but were actually taken from the cloud. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.